Roxana, it's now recording.
Thank you very much. And thank you to everyone on this call. Today is Friday, May 7th. This is the Private Probation Services Council regularly scheduled meeting. I want to welcome everyone that is here with us. My name is Roxana Gamusio. I am the Executive Director with this program. We have on the call supporting staff with the program being able to also participate and make sure we don't miss anything, as well as the attorney for our program, which is Elizabeth Bendel. And so I would like to, first of all, do a roll call vote to all of our members. If you can make sure you've got yourself on mute until we get to your piece, and that way we'll be able to record everything and post for the website as well as for anyone that needs to listen going forward. Judge Logan, are you here with us?
I'm here.
Thank you, sir. Judge Alexander?
Here.
Thank you. Judge Kane?
Here.
Thank you, sir. Judge Starnes?
Here.
Thank you. And Mr. Michael Wright?
Here.
Thank you very much. That is 5 of our members, so we do have quorum. Stacy Kelly was able to let me know that she was not going to be able to join us today, so we are good with our quorum requirements. And so I would like to go ahead and start the meeting by properly going over the information that was posted to the board's website. And proper notice was given of this May 7th, 2021 meeting on the Private Probation Services Council website on November 1st of 2019. Additionally, the month's agenda was posted and updated to the website as of Thursday, April the 21st. Next, I would like Ms. Bendel to please go ahead and read the statement of necessity on the record.
Sure. Good morning, everyone. This is a telephonic scheduled meeting of the Tennessee Private Probation Services Council. As there is not a physical quorum present, a statement of necessity will be read into the record and filed with the Tennessee Secretary of State. Pursuant to TCA 8-44-108, which states if a physical quorum is not present at the location of a meeting of a governing body, then in order for a quorum of members to participate by electronic or other means of communication, the governing body must make a determination that a necessity exists. Furthermore, TCA 8-44-108A3 defines necessity as a matter to be considered by the governing body at that meeting requiring timely action by the body, that physical presence by a quorum of the members is not practical within the period of time requiring action, and that participation by a quorum of the members by electronic or other means of communication is necessary. As stated, this was a regularly scheduled meeting for the Tennessee Private Probation Services Council, and the purpose of this meeting with members attending by teleconference is to conduct regular business, and voting will be conducted by roll call. That completes the necessity statement.
Thank you very much, Liz. We would need a motion and a second to accept the necessity statement, please.
I'll make the motion. Judge Starnes.
Thank you, Judge Starnes. Do we have a second?
Judge Logan.
Thank you, Judge Logan. We have a motion by Judge Starnes and a second by Judge Logan by roll call vote to accept the statement of necessity. Judge Logan? Thank you. Judge Alexander?
Aye.
Thank you. Judge Kane?
Aye.
Thank you. Judge Starnes?
Yes.
Thank you. And Mr. Wright? Thank you very much. Next, we will proceed to the agenda. The agenda, as well as documents needed for this meeting, were emailed to all of our members on April the 29th. If you have any changes that need to be presented to the agenda, I welcome those now. Otherwise, if the agenda will be able to be utilized as written, I would need a motion and a second to proceed.
I'll make the motion.
Thank you, Judge Starnes. Do we have a second?
Judge Logan, second.
Thank you again, Judge Logan. By roll call vote, Judge Larry Logan.
Aye.
Judge Lynn Alexander.
Aye.
Judge Brody Kane.
Aye.
Judge Gary Starnes.
Aye.
Thank you. And Mr. Michael Wright.
Aye.
Thank you. We will proceed using the agenda as it was posted. The first item there to go over is the November minutes. Those also were emailed. If there are any amendments to make, I welcome those. If the minutes looked good to everyone, I would need a motion and a second to go ahead and update those and put them on the board's website.
I'll make the motion.
Thank you, Judge Starnes. Do we have a second?
I'll second. Judge
Thank you.
Alexander.
Thank you, Judge Alexander. We have a motion and a second by roll call vote. Judge Logan?
Aye.
Thank you. Judge Alexander?
Aye.
Thank you. Judge Kane?
Aye.
Thank you. Judge Starnes?
Aye.
Thank you very much. And Michael Wright?
Aye.
Thank you. Next on the documents we provided, I included all of them as one long presentation. We will go ahead and start with the director's report. The first item of business will be to go ahead and state on the record that we follow Robert's Rules of Law. This is our first meeting for 2021 because we canceled the February meeting. So if we can please cover a motion that would state that we conduct our businesses by following Robert's Rules of Law, and we would need a motion and a second for that as well. Or if there are any conversations, I welcome those.
I'll make the motion.
Thank you, Judge Starnes. We have a motion to follow Robert's Rules of Law. Do we have a second?
Second. Judge Logan.
Thank you, Judge Logan. By roll call vote, Judge Logan.
Aye.
Thank you, Judge Alexander.
Aye.
Judge Kane.
Aye.
Judge Starnes.
Aye.
And Mr. Michael Wright.
Aye.
Thank you very much. Okay, the next item to review is informational. This is the budget that was sent to everyone. Our numbers are only as of February for the budget and what is called that net change in position. We are at a deficit of $22,000 as of February. That did not include a large portion of the February quarterly provider fees. And so I'm not sure at this time where we will end for this year. As the council knows, we expense little items as far as labor, but there are a lot of shared expenses for the program. And so we will just see as we get closer to it. We still have a surplus of $668,777. And as we discuss the continuing education piece here a little bit further, we'll talk about that bigger expense coming from our surplus and how that'll work out. But if you have any questions, I'm happy to look at those as our first item here in the presentation. Okay, the next item that we are going to discuss, and this is just a quick update, is the sunset that was presented to in front of our legislators. That meeting took place. We had a second portion of that meeting, and it had to do with being presented in front of the Government Operations Committee. That meeting took place February 22nd. And I want to thank Judge Alexander for participating. She came in person to that meeting. We had already previously done one of those, but the second set had to be heard in order for us to be approved. As it turned out, Judge Alexander, again, thank you for your time in coming here. We were not asked to provide any explanations. It was pretty smooth, and the program was extended until June 2025. So I suspect that that'll be the last update that we will cover regarding the sunset of the program. So if there are no questions with that, the next piece that I have is also an update to everyone regarding the continuing education. As the council will recall, as part of the 2018 audit, there were conversations about trying to standardize and improve the courses that our private probation officers take throughout the state. The council was wonderful, and we had work group discussions about what should be done, what was important to standardize, and the conclusion was that ethics was fundamental and that many of the companies didn't teach that every single year with the renewal period, and if they did, we had no control over it, and it was very diverse. So with that in mind, we did an RFP program process, and the company that received the contract is James Group Consulting. The contract is finalized. Judge Alexander was kind enough to participate and help us determine the important pieces that should be there. We did this telephonically through a virtual meeting. and the company has already provided several of the things for us to review. Glenn Kopchak and myself went over it, and it's looking really good. It is going to be online training. The goal of this is to have the 2-hour ethics course that the companies will be able to have. The link will be shared with them. The link will be on our website, also available, so that all of the officers can benefit and have this standard process. It's just about done. I don't have an actual date. Obviously, by our August meeting, we should be able to know by August the 6th if it's been rolled out or how close it is. But I expect that by then it will be available. We're very excited with having this, and the cost for it is going to hopefully come out of that reserve fund. That is what we had discussed in previous meetings, and I think will be able to take place. Are there any questions from anyone regarding the 2-hour ethic course?
Michael Wright, on that course, is that something that will be updated yearly, like the information provided be changed out a little bit?
That is a great question. So the thought is we are going to have the bulk of the money that was allocated for this will be paid up front because it's creating the technology, the video, and the thought is that yes, we will be able to do updates. All of our companies renew at different times, so we want to make sure to have it be consistent, allow everybody the time to take the first one. And so, that is the thought, that as new situations come up, as the judges, as you, Michael, hear of feedback, and we would like the feedback in the office as well, we will continue to make changes with that. And so, and the thought is if we needed to do an in-person session down the road, we could, but right now, especially given the times, we think that the online course option and link is the way to go, and then make changes as needed throughout. Does that answer what you needed, Michael?
Yes, it does. Thank you.
All right, thank you very much. If there are no other questions on the continuing education, I am happy to move on to the legal portion of our meeting and turn this over to Liz for the report.
Good morning again. Turning to the report that everyone should have received, there are 2 items on there. The first item is complaint 2021-009-361. And this was an administrative complaint. In December 2019, the respondent had attempted to reinstate but failed to follow up with the information needed. The respondent's reinstatement did not get approved because they did not provide the requirements or follow up. And during that time, the respondent never indicated or implied that they were operating. The respondent did not follow up until a year later in December 2020, and at this time, they worked through pending items to reinstate. And again, the respondent never indicated that they were operating. The respondent's 2019 application and the pending documents a year later all appeared to be attempts to reinstate, and the office then received the training for officers in January of 2021, which prompted confusion over the 2020 training dates. The respondent was emailed on January 27, 2021, and they responded that they did not realize that they had expired and that it was an oversight. During all of this time, the respondent had failed to provide their 2018, 2019, and 2020 quarterly fees and reports. And due to the volume of clients the respondent oversees, it was determined that the company needed to be active and a complaint was opened. The respondent did provide a response to this complaint, and they indicated that the failure to be in compliance was an oversight on their part. And the respondent has since paid the 12 past due quarter reports and fees for the 2018, 2019, and 2020 years. But the respondent has not paid any of the late fees for submitting the quarterly reports late. I'd like to open this to the council for discussion. Roxana may be able to touch a little more on this, but the respondent did fail to pay quarterly fees and reports for 3 years. And the rules and laws allow for quite a hefty civil penalty, but I'd like to discuss with the council what their thoughts on in terms of authorizing a civil penalty or how the council would like to proceed with this particular respondent. If you have any questions for me, I'd be happy to answer those as well.
Elizabeth, this is Judge Alexander. It says you received the training for the officers in 2021.
Correct.
Was that for the years 18, 19, and 20?
So, Liz, do you want me to jump in?
Yeah, if you don't
It's
mind,
Roxana,
Roxana.
absolutely. Thank you, Judge Alexander. And we may be here a minute. This is one of the main reasons that I thought the meeting would take a little bit longer. So the training for 2021 that had the training document we received in 2021 as they were finally completing their attempt to reinstate showed a 2020 date, which is what prompted, frankly, as I reviewed to reinstate them, the huge concern for that date, right? There should have been no 2020 training if they had no company, unless they were working directly under a judge's jurisdiction and paid through a different avenue. So that conversation took place because of that date. That's what jumped, if you will, and just didn't make any sense. And the reality is that training was for 2020. The company had officers, as Liz pointed out, and did not realize they expired. Their last renewal that was complete was in 2018. So it would appear that they continued doing training, it definitely did in 2020, but never renewed, never paid attention to the license they had. And then, of course, forgetting the quarterly report, which is what would have maybe prompted our office to really dig deeper, is all those pieces were missing, and there was never that completion to a renewal. So even though in 2019, for example, they they attempted to renew, but they didn't do the training documents, the bond information, and the insurance. Those three are the pieces that are needed with every renewal. And so when that wasn't submitted, the renewal stopped. They attempted to reinstate at the end of 2019, and by then the fingerprints were needed. And again, we asked for the fingerprints, we asked for the training, the bond, and they're at that point attempting to reinstate because the renewal periods are done. No one communicated that they were seeing clients, that they were open. So the logic by an attempt to reinstate is that that's what you're trying to do. And so again, the fingerprints weren't sent in, the documents weren't sent in, and that brought us to December 2020 when the fingerprints for their officers were submitted and the documents. And that's where we saw the 2020 training that shouldn't have existed. So it's probably a lot of information and sounds confusing, but the whole thing is confusing. As Liz said, we have received 12 quarters. So we're talking about 4 quarters for 2018, 4 quarters for 2019, and the 4 quarters for 2020 were received on March the 3rd. They were received with the complete information, the notarized form, the number of clients, and I've done a quick spreadsheet to kind of help myself answer any questions you might have. They had an average of over 500 clients throughout the entire time. 508 is the exact number if I average those 12 reports. And so that is the reason Liz and I had to meet and talk and get them reinstated, because they have been open this whole time. They've been seeing clients and doing business, just not completing a renewal, not reaching the board office, not providing quarterly reports. I would have to guess not providing quarterly information or information to the clerk of courts or their judge. I'm kind of at a loss, and we need guidance on what you think, but not reinstating them did not seem to be the right path to go. We really needed your conversation and guidance on what to do next.
Thanks,
Well,
Roxana.
first of all, if they haven't done this after 3 years, they don't need to be reinstated. And if there's a civil penalty, they need to be hit with a civil penalty.
I agree.
This is absurd.
Yes.
How
This
much
is
is
the
a civil penalty?
So as you can imagine, that the statement for the civil penalty, which is still in our rules, and we'll talk about those later as well, because we've addressed the 5 cents for every 10 days times the number of clients. The number of mistakes that are done due to that small penalty has been ridiculous. We've been written up during an audit because they miscalculate, we do refunds. So it is going away with the rules that we have in the pipeline, but during these 3 years that they didn't do it, the penalty was definitely there. I attempted to calculate the number of days. I'll be honest with you all, you don't want to hear the figure because when I look at February, the report that was due February 20th of 2018, it's 1,100 days late, right? And so at 489 clients they had for that period, it's in excess of 50,000. And so
Yeah.
the reality is that's the reason we didn't even touch on the penalty. Now, I've spoken to the owner and said it will be at the council's discretion what we do. But because all this was finished and the conversations took place in February, we were opening the complaint. That was the first definite process. And then it would be in your hands. And I did state very likely the council might not be in agreement that this should be reinstated, which is completely in your purview. The council can refuse to renew, deny, suspend, or revoke based on noncompliance. And this particular company was also looked at by our auditors who were finishing the last piece of the audit, and they understood that given that number of clients, were we to reach the court, what would be your guidance? And so for now, they're operating because they have been forever. So civil penalty, I think Liz can answer. I think there's no limit given the time frame that they've operated without a license and without a report that is the fundamental piece of knowing what clients they're overseeing.
Yeah, essentially what Roxana said, it's about $1,000 a day since 2018, which I'm not good at math, but that's in the hundreds of thousands of dollars at this point. So
Where is this coming from? Which district is this?
County, it's in
Yeah.
Hawkins County.
Typically there should be a judge overseeing this or a member of the DA's office at the judge's direction. I think we ought to do a letter to the judge or maybe to the DA's office too, setting out what was going on, that we need more oversight. I don't know, maybe I'm off base there, but
Is this
Okay,
Judge Kane?
yes, ma'am.
Okay, thank you, Judge. Judges, anything else? I've got your note, and you've said kind of what I thought would be one of our conversation pieces, right? I didn't think it was in my purview to reach the judges. I mean, we could have, but given the shock that this took place, checking on the money got here, but with no penalties. I mean, the total amount that we received for all those quarters is $4,569.75. So it isn't a money thing. It's that magnitude of that report, what that signifies to us, right? We had no reason to think a company would be operating, or we would have handled it differently. So thank you, Judge Kane. I've got that piece. Anything else, judges?
They're still not in compliance, right?
Well, the piece that they're missing to be in compliance is we did not follow with the civil penalty for paying late. Because again, if you're 1,106 days late for the February report and you had 489 clients, that's a lot of money. So this is what would be up to you all. They're still missing that penalty if that is the way the council wants to proceed. If we are proceeding with the conclusion that they were completely non-compliant and shouldn't have been reinstated, that's a different conversation. And then the letter to the judge for that district and the DA is something I would like to make sure that we're all in agreement to follow up on, and anything else you see fit.
So what you're saying is they are in compliance finally, but the only issue that you're looking at here, or we're looking at, is whether or not to not renew the license or just the penalty itself. Let them keep the license and the penalty itself.
Correct. I think so, Judge Starnes, because our concern when Liz and I looked at everything was having over 500 clients all of this time. How is the judge for that court going to react? I don't know. They might have thought why would they think the company is non-compliant, right? And I don't know that answer. They should be reporting and providing those quarterly reports to that court. I don't know that they did, because the reports we received on March 3rd, 2021 are current. I mean, they were just completed and notarized. So it's not that they sat somewhere and forgot to mail them and cut the check, if that makes sense.
I think they should still get a penalty.
Yes.
For delaying and stalling around. They have plenty of time. They have no reason not to have done this. and they're just thumbing their nose. So if they've gotten reinstated, fine, but they should pay a penalty, whatever that amount should be, for what they've done and their actions they've taken. That's just my opinion.
Okay. All right. This is Judge Alexander. Number one, they were to provide quarterly reports to the judge. If they didn't send them, that's one issue. They violated their obligation. They violated the law. If they did, then they knew that they should be providing the same ones to us. So either way, if you just look at the quarterly report issue, they're thumbing their nose or they're not telling the truth.
Right.
If you refuse to reinstate them, they have a right to a contested case hearing, correct?
Correct.
And then that would provide us as the council more information as to what's going on and allow us at that point to determine whether to stay with the refusal or to do something different. But a full-blown hearing would allow them to bring everything to us instead of relying on back and forth, and them continuing to operate. And if I'm not correct, please let me know.
I think you are, Judge. This is Roxana. Liz?
Yeah, I was going to say you are correct, Judge.
But
So,
this is Judge King, so they've already been reinstated, right?
Yes,
correct.
we reinstated them, I believe, either late March or maybe early April, based on all the reports here. The training for the officers was provided, the insurance is current, the bond, and we'll talk more about some of the additional things we need to do to make sure our companies are doing the really showing us everything, but to the basic information that we need, they provided that. They have not provided the penalty, and they are well aware that this complaint process is going to determine the future, right? That it is the council that had the ultimate responsibility of whether it's a civil penalty. No, we don't let them continue, and we go through the complaint process, and it plays out exactly as Judge Alexander pointed out. We send a letter to the judge in that district and the DA to figure out what else was going on.
Council, also just as a note, we could proceed another route just for consideration is that if we do send this letter to the judge and the DA and it's determined that there were additional violations in terms of them not providing, because we don't really have a clear answer on whether they've been providing to the judge, that also provides for an additional complaint to be open administratively, and then a similar decision on whether or not from there we'd like to deny their renewal and proceed to a formal hearing or an additional civil penalty as well. Just so everyone's aware, that's also an option.
How long has this
Michael,
company been in business?
I'm sorry, Judge Alexander, did you have a question?
I'm sorry. How long has this company been in business?
Roxana, do you have the data on how long this company has been operating?
I do. They were originally licensed in 2014, June of 2014.
Yeah. I'm wondering is they have maybe a new person running the show now? They've got this thing cured, or is this the same folks? I'm kind of curious about that.
The ownership itself has not changed, but that was part of the explanation we were given, that, you know, they just didn't know they were missing these things. They weren't getting all of our emails. They didn't realize that this was happening. They didn't throw any name under the bus, but it sounded like something administratively just fell apart, and they just forgot that the renewal even existed, even though they would have renewed in 15, 16, and 17. They would have had 3 renewal cycles.
Yeah.
That's what I was.
I don't buy that one bit. This is a company that has 400 plus people. They know
Yes.
exactly what they're supposed to do, and that just doesn't work.
I agree.
Michael Wright, as far as the civil penalties, would that, I guess, fall under the category 2, where it's 300 to 699 per violation, considering the periodic reports, since
Yes,
it's not reinstated?
you are correct. Yeah, it would fall under that category too. But they also, I think that there's also some violations under that category 1 as well for failure to provide documents or failure to produce reports.
But were they providing training during that period of time?
If they were, it was directly to their officers. We don't have the supporting document, and to be honest with you, they likely were, because that's the reason we caught that date, that in 2020 there was training done, and that made no sense if they in fact weren't operating as a company under our jurisdiction. So we could ask.
Well, then they knew. If they knew they were supposed to provide training, then they knew that they had an obligation to provide the quarterly reports. I don't know. I go back to the simple, that's your job. Your job is to know what the law is. What if this was a child care agency and came in and said, oh, we didn't know we were supposed to provide training for our employees to take care of children. Or we provided the training, but we didn't know that we were supposed to provide reports to the state. These are vulnerable individuals too that are on probation. And this company is in charge of their lives.
Absolutely, Judge Alexander, you're 100% correct. You can imagine our conversations, I guess.
Better you than me.
Yeah.
This is Judge Logan. I think this is a chance for us to make a statement.
Where do you
I
propose,
agree.
Judge?
Gary, I'm leaning toward a hefty fine. Can we put these? Well, I don't know. I've got mixed. I just think the legislature was on us because we were. I think they thought we were not keeping tabs on these people, and I think there's got to be a hefty fine. I don't know about not letting them renew. I don't know.
Yeah, I kind of fall on the side of a fine rather than not letting them renew it. I mean, we can still keep a close eye on them, and if something were to happen again, but I will agree with whatever the body feels should be done. But I kind of agree with Judge Logan. Maybe a fairly hefty civil fine might do the trick, but I have no idea how to come up with that fine. I mean, as far as
if we did, how long do they have to pay it?
Judge Alexander, so under the department's rules, we usually, I would send a consent order that, provides for the fine within 30 days. There are payment options in certain situations, and that has to be paid over a year. And then we have to get approval from the commissioner if we want to go beyond that year. So I typically do not allow payment plans beyond a year, but
how much did you say they paid to get all these quarterly fees paid? Was it 11 or 12,000?
No,
Is that
not
right?
even. It was
$4,000.
$4,569.75. Now, you don't want my estimate of what the civil penalty would be for the 5 cents times 10 days. They were, if I added all the days late for all the quarters, like I said, February 2018 is the latest. That one alone is 1,100 days late for 489 clients. That's $54,000.
All right. Well, we don't have to do the entire amount, so we could do $40,000.
Yeah.
And we've
Yeah,
got to
there's
do
no-
something to stop these people from doing this. I mean, they've had plenty of time to do it. Their company's been out there and they've been handling all of these probationary cases knowing they weren't in
And they're-
compliance.
And they're
If it-
getting how much per person a month from those people? They're getting $45 a month per person from those people.
That's correct, Judge Alexander.
They're getting 45, let's just say $40, because I don't know about you guys. I went to law school, so I didn't have to do math. So $40 times, 30 days per month, per person is what they are bringing in. Now, one suggestion, and if I understand you correctly, Roxanne, that if you just took the 2018 amount, that would be 50,000.
Yes, Judge, it's 54,000 and change. So if we round it down, that piece alone is 50,000.
Wow.
Okay. Then you do 2019 is another 50. 2020, another 50.
And of
If
course,
it falls under the category 2 on the quarterly reports, what if we done something like the upper range of that, $6.99 per quarter that they didn't submit?
What if you did the 54,000 for 2018 and allowed that to encompass 19 and 20? And it's like your $50 per day for every day you're not in compliance, which is, what we have for our, municipal codes. This is so much per day for every day not in compliance.
Well, let's do the 54,000. And if they want a hearing on it, fine. But it sends a message to them as well as other organizations that they need to do what they're supposed to do.
And you're sending a consent order, so either they agree to pay it or they ask for a hearing, correct?
Correct, Judge Alexander. And also just something that goes in the letter and goes in the consent order is that if it does go to hearing, that brings around the option to revoke their license or not reinstate or suspend their license.
Judge Starnes, is that a motion?
That's a motion from me.
I second it.
Judge, is that Judge Logan?
Judge Kane.
Judge Kane, thank you, Judge. I was missing that. Okay, so we do have a motion from Judge Starnes and a second from Judge Kane. And the motion, I want to read and make sure I'm understanding, is for $54,000 civil penalty. It would have the standard language for 30 days payment. And then obviously the consent order, if they don't pay and follow up in 30 days, this would proceed to a hearing just like our standard processes. The only other question I would like to add is if the council would like a letter to go out to the judge and the DA for that area, because along with all the conversations we're having, our big concern and the reason we're here is to protect the public. And these are clients, exactly as you've pointed out, that are vulnerable, that need to have this consistency and us follow through. And this completely, it just couldn't have done any worse, in my opinion. And so what do you suggest we do that? And we can continue talking about that. I just want to make sure that the motion and second is correct and I can do roll call vote and then we discuss the letter to the judge and the DA. Does that sound okay, Judge Starnes?
Sounds great to me. And I think they should get a copy of the consent order, I guess, and let them know what we're doing.
Yeah, that might serve the same purpose.
Okay.
I just want to put on the record, so we're authorizing for a formal hearing and then authorizing that $54,000 civil penalty in addition to a letter that will go to the judge and the DA. I just want that to be noted. Is that correct? And then we can do a roll call on that.
And that's fine with me because I don't want to have a long explanatory letter to the judge. A consent order will let him know, him or her, and we can go from there.
I agree. I think that's best.
So Liz, just
I
the
agree.
consent order, not a separate letter.
Okay.
Perfect. Perfect. Okay, so we have a motion and a second and are all in agreement of the 54,000 civil penalty. Liz will prepare the consent order with the standard language, and that copy of the consent order, as soon as we have it done, will go to the judge for that jurisdiction and the DA. So by roll call vote to agree to this first case on our legal report to Judge Logan.
Yes.
Thank you. Judge Alexander,
Yes.
Judge Kane,
Yes.
Judge Starnes.
Yes.
Thank you. And Mr. Michael Wright.
Yes.
Thank you. Liz, I will turn it over to you for the second case.
Thank
And
you.
I would like to get a copy of that consent order, if you wouldn't mind emailing it out to the members.
Okay, I just
Absolutely.
want to note that it is, it can't be shared if I do send it out because it's protected, and once it gets
Oh.
shared, then
Okay.
All right.
breaks that privilege. Item number 2 is complaint 2021-007461. And this was the complaint submitted by an assistant public defender for Smith County alleging unprofessional conduct by the respondent, who is an officer. The complaint alleged that the respondent is unresponsive and unreasonably delays all requests for in-person, electronic, or telephone requests. Additionally, the complaint alleged that the respondent gives the false impression of their authority to individuals by testifying that they relay and negotiate in plea offers with attorneys. And the complaint alleged that the respondent is biased and interested in their financial gain at the expense of vulnerable probationers. Based on these allegations, this complaint was sent for an investigation. In March 2021, a field investigator interviewed and obtained documents from all the parties involved in this matter. The investigation shows that the respondent claims to be acting in accordance with the court orders and directives, as well as the governing statutes and rules when processing individuals assigned to them. The investigation corroborated that with documents provided and by the correspondence received from the General Sessions Judge, and no violations were found in this case. It's legal's recommendation to close this one.
I want to be heard on this one. This is my jurisdiction. It's my understanding, again, this is hearsay, but that this probation officer has testified under oath admitting some of these allegations. Basically, as I understood it, sign here for an extension or I'm going to violate you, to give you a chance to pay your money, and people were doing it, without due process. So I don't know. I don't think the complaint maybe was the best worded complaint I've ever seen. But my other question is this: as a result of all this, Smith County has now removed this private probation and gone to a government-run program. Upon that, with them doing that, are we still, if we want to take an action, do we still have jurisdiction over them? I mean, there's really no entity there anymore.
I was not aware of that, Judge Kane, but we would not then have jurisdiction over them if they're not run by private probation.
Wait. I think we would.
Judge
Because
Alexander.
and I may be wrong, but I think we would, because this offense occurred while they were under our jurisdiction, correct?
That is correct. Yes. Yeah. You are correct, Judge Alexander. Yeah. So, I mean, if you would like to take action on this, then we could
I mean,
proceed
it seems moot
Yeah.
if they're not in business anymore, but I think that we would still, like, we could impose something on them if we chose to, but if they're not, are they not in business in Smith County, or are they not in business at all?
They are only, to my knowledge, they're only in Smith County, and it's now gone to like I said, they've changed to a government run. It was kind of a mess, but I just don't know whether it seemed like there was more there than what was revealed in this investigation. But I don't know. I don't have the complaint in front of me, and I read it some time ago, but maybe it didn't cover everything that was going on. But I don't know who to even do it. Who are you going to send it to? There's no there. So maybe closure is best, but
Is that individual employed by the county now?
Well, they've changed. They've gotten rid of her and they brought in somebody new. She's
Good.
totally out now.
Well, it might be a good idea to close it, and if it comes up later, we can bring it back up later.
Yeah. That'd be
Mhm.
fine with me.
Okay, so just for the record, we're going to close and we can flag this in case an additional issue arises or complaint arises related to this matter, and we can address that at a separate meeting.
I have a question. Can we read the complaint and read the investigator's report?
Yes, you have access to that. Again, that's all protected. So if it were to be shared with anyone, then we lose that privilege. The complaint is obviously open to the public under the Public Records Act, but the investigation itself is protected.
Well, and I'm not, I may be overreaching, and if I am, I apologize. But the complaint says that the respondent gives a false impression of their authority by testifying that they relay and negotiate plea offers. And the judge just said, you know, they testified in court that they were doing that, but then the field investigator doesn't find anything wrong.
Judge
What was
Alexander, I'm not the field investigator, so I can only speak to what I
See,
read in the investigation.
That's why I
See,
said
that
I
was
may
my
be
concern.
overreaching. But that's a concern of mine. If the field, you know, what did the field investigator look at to determine, oh, well, there's nothing going on?
Yeah.
And it
I mean,
must
this can be
that-
sent for further investigation if that with a separate investigator, if that's something you guys
Sounds like a good idea. We can deny the closure, keep it open, do a further investigation, and bring it up next time.
Let's do that, and maybe they can get some transcripts for that investigator to review.
Yeah.
okay. So I will send this one back out for investigation under a different investigator. Could we get a motion on that?
I'll make the motion.
And I second it, Judge Kane.
Thank you. We have a motion. And who was the first motion? I apologize.
Judge Starnes.
Judge Starnes, thank you very much. We have a motion by Judge Starnes and a second by Judge Kane. And on this particular number 2, it's not following the recommendation. This is going out for further investigation. And we'll make note that transcripts of the hearing and additional information is needed. I also would like to know if this particular license company is no longer providing services to that jurisdiction, is their intent to stay open? Because just so we know what to follow up with.
Yeah.
So we'll put that in writing. Let me do a roll call vote to make sure we're all in agreement. Judge Logan?
Yes.
Thank you. Judge Alexander?
Yes.
Judge Kane?
Yes.
Judge Starnes?
Yes.
Michael Wright?
Yes.
Liz, I think that's the 2 on the legal report. Do you mind if we continue on this path of non-compliance before we move
Yeah.
over to the rules? Okay.
Yeah.
So this couldn't have come, I guess, not that this is a great time, but we're here. We had non-compliance from one company that reinstated, even though they'd continued doing business. We're looking at, you know, protecting the public and these clients. And so one other company to discuss briefly is at our previous meeting, we had a complaint on a company that did not renew, yet we knew they were operating. We did a $2,000 civil penalty that they were to pay within 30 days and get finish the renewal process. That company has paid the civil penalty, but the complaint is still open because they are not completing the documents for the renewal process. And so I will try to make sure that my frustration doesn't show, but you can imagine this has been going on since August of 2020. We have emailed, we have called, we have followed up and followed up and followed up. And as we wrap up our audit, with what I would love to see, a flawless audit, because that's the way we run our business and all of our programs. And so to me, any finding is not acceptable. We have not only these two companies we're addressing, but others that just cannot seem to be in compliance. And so addressing the one company as an example, they've paid the civil penalty, they've signed that consent order, but they've not finished the renewal. So as of August 2020, they've remained to be on this expired piece, and yet they're seeing clients. And so the case is open. I just want us to have that thought as we talk about non-compliant companies. What else can we do for these companies that do not finish this renewal process, yet we know they're operating, their judges might think everything's perfect. And so I would like to propose we have the complaint process take care of this. And if they don't renew and we have followed up, let's say 60 days is what the council members decide is a good follow-up period after they've expired. We have a company right now in March that is still expired. We email, we call, they know what we need. We are promised we'll get it tomorrow and nothing happens. And we live in this vicious circle. It is going to be a finding on our final audit, just that we don't get those final documents the way we need them. And so my thought for everyone to think about is, if we open a complaint, it's an administrative complaint for the lack of follow through on these minimal compliance items. You are still expired and not providing what is needed. Training documents, insurance, bond. Yeah, the basic documents they need to provide. Then a complaint is open administratively. But I would like us to set what that complaint's about. It is an agreed disciplinary process with whatever the number is, a civil penalty of $100 or $200. You get the complaint, you need to handle it, pay for it, and bring the things that are needed to code to meet the requirements, and we close the complaint. In other words, the calls and the emails aren't working. The complaint process is now part of your record, and maybe that complaint also goes to your jurisdiction. I don't know, but these companies have, not all, so I don't want to say, and not even half, but a lot of them just drag the back and forth. And it makes me nervous. If they're doing that with my calls and emails and Katie, who handles the program, then are their clients being treated right?
Michael, right. I believe it was Judge Kane that mentioned earlier about sending a letter, maybe other things that get implemented, but I think it's important for the courts to be informed that they may have a provider that's not in compliance. So could that be some sort of standard of sending a letter to the jurisdiction?
Absolutely. And so we have different, I'm calling them an agreed disciplinary process, an agreed process with which we set in stone when this doesn't happen. And that this would be, if you don't renew on time and we give you an additional 60-day grace period where we, myself and Katie, call, email, send follow-ups and courtesy reminders, we still want to do all that. But at a certain point, that hasn't worked, then here's what the complaint process follows. We open a complaint, we send a letter to the jurisdiction that you fall under. You're given 30 days to make everything right and pay some type of penalty, and then the complaint can close.
Why don't we send them a letter? Why don't we give them notice and do it in 60 days? Your license is going to be suspended administratively,
Okay.
and then start the process of having a hearing. Leave it up to them, send it to the judge. I mean, it's ridiculous if these companies keep doing this, and it's not fair to the ones the probationary people they're representing. They're not in compliance, and it again sends a strong message.
Judge Starnes, I agree completely. Any other thoughts? So the notice you're talking about is not a letter, but the complaint itself. Open the complaint, which would be their notice. 60 days to make it right. That notice could go to the jurisdiction as well. And if everything is not turned in within 60 days, they would be suspended. Is that correct?
That's right. It may be subject to a penalty.
Okay.
That will get their attention.
Any other thoughts, judges? My thought was also whatever we decide here to do for this complaint process, I'm calling it a complaint process for non-compliance, right? And because they renew every year, we're in this vicious circle. And we would also, if they make it right, which is the goal, and learn from it, and it doesn't happen again, we can close it without it needing to be presented even to the council. I would always update you and say, between the May meeting and the August meeting, we opened 3 administrative, hopefully not, but at least 2 administrative complaints. Those companies took care of it. They did everything that was needed. Apparently this worked, and we've closed those complaints. That would be a great thing. If not, we would have to move forward to suspension and deal with it there.
Okay.
I agree.
Do we
Yeah, I
foresee?
agree too.
Okay. Do we foresee this having a civil penalty as part of the process?
Well, that leaves it open for us to decide.
Okay, and the only downside to that is then we would not close it. It would wait for each of your meetings to decide. If we did something that was set in motion with notice, 60 days to respond and get in compliance, or you're suspended and a civil penalty. And then if they met all those things, we would close it in between meetings without it needing to wait. If they didn't take care of any of that, then yes, the suspension would take place
All right.
and it would likely come back to you.
How much of a civil penalty? $5,000?
Ooh, that's high.
I was
Okay.
thinking like 500.
Okay.
Okay.
Let's go with 2,500. I'm just kidding. It doesn't matter to me. But I really think that at least $1,000. Again, these people are making
Right.
money.
The 500 would fall under the category 2 violations involving noncompliance, so that would
I was
make
just
sense.
gonna say, the penalty, I mean, depending on the amount of days, it obviously could be upwards of, like you mentioned, 2,500, Judge Alexander, but I think 500 would fall in that category too, in case there's only one violation there. That would fall within our rules guidance on civil penalties. Obviously that can be, that every day of that violation makes that penalty larger, but just as a baseline, it would be between 300 and 699, which 500 would fall within that.
Okay. Let's do 500.
All right.
Okay. If we could, I think I have a sort of a motion, but I will let you all recant the motion and then a second. And we're looking at these being administrative complaints for non-compliance. And at the moment, the first thing that we're seeing a lot of, and this will be our only finding on this finish up audit, is the fact that we still have these lingering few companies that are really not doing justice for those that follow through. So it would be a complaint process opened administratively to be resolved within 60 days. Part of the resolution is getting in compliance with the renewal documents required by the statute, as well as a $500 civil penalty. If that takes place in that timeline, the complaint would be able to be closed and we would update the council at every meeting, but it wouldn't linger open. If it is not resolved, then it would be presented to the council. Does that sound right?
Sounds good to me.
Is that Judge Starnes?
Yes.
Okay, so Judge Starnes, I think that was sort of your motion. Does that sound correct?
It is. I'll
Okay,
make the motion.
thank you, sir. Do we have a second?
Judge Logan, I second.
Judge Logan, thank you. We have a motion and a second to start what we're going to call this complaint process for compliance for the program. And so I will do roll call vote to make sure we are all in agreement of starting this. Judge Logan?
Yes.
Thank you. Judge Alexander?
Yes.
Judge Kane?
Yes.
Judge Starnes?
Yes.
And Michael Wright?
Yes.
Thank you. Liz, I will turn it over to you to continue on the agenda. I think we're on the rules update.
Hey, Roxana,
Yes, Judge.
are we, because I've got a 29-page docket that I've been putting on hold. If I exit, would we still have a quorum?
Yes, sir. We have a quorum. I can't thank you enough for your participation. I think the heavy lifting, we are done. We have only one more thing at the end that I don't think will be a problem. So we will have quorum, sir. Yes.
All right,
Thank you,
if I,
Pastor. Have a good week.
thank you, Larry.
Thank
If
you.
I
You
leave,
too.
if I leave, we won't have a quorum, will we?
No, but we should be done soon, Judge Logan. Are you needing to
All
leave
right.
us as well?
Well, Judge Starnes, yeah,
Oh,
I've got a
Judge Starnes.
courtroom full of people, but if we're just going to be a few more minutes, I can do it.
I'll
Okay.
keep it very quick.
No, that was
Thank
Judge Kay.
Just to wrap up, our rules on where we removed that 5-cent penalty fee, and then we had to match our renewal late fee to the 2019 legislation are moving along. We have an effective date of June 10th, 2021. And that it'll be heard at the Joint Government Operations Rule Review the end of this month. So hopefully at our next meeting, those will be effective, and that'll be great news. If anyone has any questions about those, I'd be happy to answer them, but that's my only update on those rules.
Thank you, Liz. Hearing none, I think the last item on our agenda is I put it on there to discuss the mandatory bond form. This is in line again with the final review audit that we've had with internal audit that has gone very well. The points they made, as you're hearing today with the different complaints, they're true. And so we're making every effort. And with this meeting and the decisions the council has made, I'm going to be able to write my response. One of the items that they pointed to that I wanted just to make sure to go through with you all quickly is that the actual performance bond that is in our statute mentioned in our rules is not being used by most of our companies. And so, they all attest to the fact that there is no change, but they complete bond forms halfway through, and many times they just provide proof that they paid for the bond, but we don't see the bond no matter what we ask for. So the auditor's recommendation and the conclusion I had also come to is we're going to need to do an entire renewal cycle where we have every company complete the performance bond that the state of Tennessee Comptroller's Office requests. It's actually in our rules. We've just never pushed it. And so we can start with the August renewals because they've not gone out yet. When a company renews, we will make sure that they have at least once provided the completed form and that they are filing it with their jurisdiction because it's supposed to be on record, and I'm certain that it isn't. So any questions, thoughts, or concerns? It's going to take us a minute on those renewals, but we did it with the fingerprints. We did an audit. It went well. It was very intense labor-wise, but I think this is very needed, not only because of the audit pointing, but because we just don't get completed bond forms, and they're there to protect the clients again. So they are going to have to follow in the next cycle and show proof of this approved bond that is on the board's website. It has always been on the council's website. We're going to send it through with a letter to every single company when they have to renew, saying that this must be completed, notarized, and no lines missing. So any thoughts, concerns that we can proceed with that?
Judge Logan, if they're supposed to do it, I think we need to make them do it.
Perfect. Thank you, Judge Logan. I don't know that to enforce what we're supposed to enforce and what they're supposed to do, I need a motion. I think we're good. I just want to make sure that everyone knew, in case you are questioned by your colleagues, other companies, that we're going to start that in as soon as we can. And I think the August renewal companies will be the first, and we'll move forward with that. So I appreciate. Are there any other questions? Okay, hearing nothing else, we would need a motion and a second to adjourn.
I'll make the motion.
Thank you, Judge Starnes.
Judge Logan, I'll second.
Judge Logan, thank you. We have a motion and a second to adjourn, and we're ending at 11:07. Thank you very much to everyone for participating. This was an extremely needed meeting, and I'm looking forward to us not needing to open a lot of complaints, but for companies to learn from it. So I thank you very much.
Everybody have a
Thank
good
you.
weekend.
You too. Thank
Thank
you
you.
all. Thank you.
Bye,
Bye-bye.
guys.
Bye.